Intellectual Property Rights, an introduction by Origin IP Academy for intellectual property learning. About the course. After an invention is conceived, searches may be conducted at different stages. For example, before making a decision to file for a patent, during the prosecution of the patent, and after a patent is granted, or during the litigation of a patent. And normally, searches are also conducted when one decides to market the invention. These searches are performed to ensure patentability, marketability of the invention in terms of novelty, non-obviousness, and industrial utility. Purpose of the searches is to discover prior art on which the invention may infringe, which can make the invention invalid and thus non-patentable and or non-marketable. However, identification of correct keywords, formulation of appropriate search strategies, assessment of identified prior art, evaluation of invention against statutory requirements is extremely critical for performing these searches. Once search is performed, a report or opinion is produced based on which the inventor can decide on the next course of action. The introductory course is designed in a way that it introduces intellectual property and its requirements to novice readers. Who should take this course? The course introduces fundamentals of patent search to the participants using simple terms by keeping the flow interesting and well structured. More specifically, intention of this course is to help people who work in the IP department of companies, patent law firms, researchers, science graduates, engineering graduates, and anyone who would like to step into intellectual property area. Outline of the tutorial. Flow of the tutorial is depicted as a flow chart in this slide. The introductory or basic module is divided into 6 parts for easy learning. Part 1 teaches IP terms. Part 2 teaches IP conditions. Part 3 and Part 4 describes non-patentable inventions. Part 5 provides some points to remember. Part 6 touches upon the need of different types of searches in the patents area. Sample terms introduced. Introduction of terms like intellectual property, patent, patent rights, inventor, limited period of time, person skilled in art, prior art, and much more. Conditions discussed. Novelty, anticipation versus non-obviousness with examples and case laws. Utility, inventive step, are these inventions patentable? A machine giving 100% performance. A gambling machine. An invention that was found to be causing damage to the environment. An instrument specially designed for thieves to steal from a bank. Are stem cells patentable? A substance or microorganism occurring freely in nature, is that a discovery? Method of doing surgery, a software program. A mathematical algorithm. Television production. Method of playing a game. IC chipboard. What is your answer? Check out introductory module. Study part 3 and part 4 of the introductory module to discover what are patentable inventions and in which countries. Points to remember. Read about interesting court cases in US, India, Europe, China, from old times till current. Establishment of anticipation. Why should one establish novelty first before establishing inventive step? Case laws discussed. Immersion versus Sony and Microsoft. Abbott Labs versus OmniCef. Philips versus AWH Corporation. patent search? Why conduct a patent search? When is a patent search conducted? Where is the search performed? Who performs the search? How is a patent search performed and by whom? To know the answers, please go over our first module called Intellectual Property Rights and Introduction. Is there a difference in patent laws of countries? What do you think? Yes, there is. Comparative account provided in our introductory module for US, Canada, Australia, Europe, China, Japan, and India. If you have any questions, please write to info@originipa.com, or you can call the numbers provided on this slide for further information. Please visit www.originipa.com. Thank you.